Good day to all. I'm Sarthak Kalra, Senior Legal Associate at the Indian Lawyer. We are fortunate today to have Mrs. Sushila Ram Varma, Chief Legal Consultant, with us. Sushila ma'am is a very senior lawyer and has been practicing before the Honorable Supreme Court and various other high courts and tribunals across the country, along with international arbitration. Today, we'll be talking about the concept of death penalty in the Indian legal system. Let's take a brief insight on the matter from the expert herself. Over to you, ma'am.
Thank you, Sarthak. Sarthak, to make it interesting, I thought we should first discuss the history of death penalty in India. As you know, capital punishment is not something which is new in India. We used to have it in the days when we had kings ruling the country. Then we had it again when the Mughals were there, but there was a great amount of cruelty that was exercised by these rulers, probably to create a fear psychosis in the minds of the citizens. And then when the British came, they continued with death sentence and capital punishment, and they also took it to another level. They used to do things which were really shocking. They used a method which was known as blowing from a gun. During the 1857 Sepoy Mutiny, this practice involved tying the condemned to the mouth of a cannon and firing. Obviously, this ensured that the body of the condemned was in smithereens. The idea was that they wanted to terrify the mutineers and rebels, and also to give some kind of a symbolic form of punishment that would actually quell the dissent or assert their dominance. But frankly, it didn't work because, as you know, we fought for independence and we won our independence. Now, post 1947, we still had the capital punishment. However, the Indian laws reduced it to what is known as the rarest of rare cases. This term was coined in a judgment known as Bachan Singh versus State of Punjab, 1980, where the Supreme Court upheld that death penalty can only be given in the rarest of rare cases.
What is the specific law that deals with death penalty in India?
I would say the most important law that generally deals with the death penalty was earlier the Indian Penal Code, which is now replaced with the Bharatiya Nyaya Sanhita, or the BNS. Now, what the BNS has done is, apart from those offences which were there in the IPC, they have now introduced new offences punishable by death, which include mob lynching, repeat rape offences, organized crime that leads to death, and terrorism that results in death. There are also some specific provisions for minors in which death penalty has been given to minors who have been guilty of doing heinous crimes. Apart from that, there is an enhanced punishment that the BNS has now started giving for certain heinous offences. For the convenience of our viewers, Sarthak, I thought we should just place the offences on the screen below so that they can see what are the offences under which death penalty can be given.
Well, ma'am, who is it that can actually commute a death sentence?
According to Section 54 of the IPC, which is now Section 5 of the BNS, the government can commute. When we say government, we mean the President of India or the governor of a state that can commute, that is pardon, any punishment which has death sentence.
And ma'am, if I may ask, what is the process for execution of death sentence in India?
Well, the process of giving the death sentence is that whichever court gives the death sentence, it has to be accepted, or it has to be upheld by the High Court of that particular state. Thereafter, the matter goes to the Supreme Court, well and good. In any case, when it comes to the actual process of execution, what happens is typically the convict who is held is given a death by hanging.
Could you also discuss any specific case law which is regarding death penalty?
Yes, of course, Sarthak. Like I said earlier, the primary case that concerns death sentence in India is what is called Bachan Singh versus State of Punjab, 1980, in which the matter was decided by 5 judges, that is the Constitution Bench of the Supreme Court. Now, what the Supreme Court did in this particular case was upheld Bachan Singh's conviction for the brutal murders of his wife and two children. The trial court had sentenced him to death, and the same was upheld, the sentence was upheld by the Punjab and Haryana High Court. And then Bachan Singh, when he challenged it in the Supreme Court, was of the opinion that this particular sentence was against his constitutional or fundamental rights. That is, it violated Articles 14, that is right to equality, Article 19, that is freedom of speech and expression, and 21, that is right to life and personal liberty. The Supreme Court, in a 4-1 majority decision, upheld the constitutionality of death penalty, but introduced significant restrictions, and they established what we in today call the rarest of rare doctrine that details the guidelines for its imposition. The judgment till date remains a cornerstone for giving death penalty in India. Now,
If I may ask, what were the guidelines in this case?
The basic key principles that were established is the court felt that the constitutionality of death penalty was not violated. Some key principles were established in this case. The court held that death penalty as provided under the law, which guarantees the right to life and personal liberty, is not affected by a death penalty. The majority opinion was that death penalty serves as a deterrent for cases which are extremely, I would say, extremely barbarous in nature. Now, what happened was in this particular case, the rarest of rare doctrine that was upheld restricted the death penalty only to exceptional cases where the crime was very heinous. Otherwise, life imprisonment was given. Now, there are certain guidelines that have been imposed by this particular judgment, and this is what is known as the two-stage trial process. That is, the trial must be bifurcated in 2 stages. One, to determine the guilt or the conviction, and second, the power to decide the sentence. This ensures that the sentence is not automatically given, but based on a very careful evaluation of the case's facts. Aggravating and mitigating circumstances must be taken into consideration by the judge. Also, there is a proportionality test which says the punishment must always be in proportion to the crime. Also, interestingly, this case talks about the reform test. That is a test where reformation, if possible, should be considered. Finally, there is something called the special reasons requirement, in which the court must record the special reasons for which it gave the death sentence. So this is what the court has finally held.
Apart from this specific case, are there any other case laws as well upon the issue?
Yes, of course, there are other cases. There is a 2023 case known as Madan versus State of UP, in which the incident involved Madan and Sudesh Pal, who along with others were convicted for the murder of 6 individuals from political rivalry in Uttar Pradesh in 2003. The trial court sentenced Madan and Sudesh Pal to death. The High Court, however, only confirmed Madan's death sentence but commuted Sudesh Pal to life imprisonment. The Supreme Court, when the matter went there, assessed whether Madan's death penalty should stand and decided that yes, it should. The Supreme Court recognized that the heinous crime of 6 brutal murders to cause societal terror fell within the purview of rarest of rare cases, and felt that there were aggravating circumstances due to which they must give the death sentence. Now, there is another case that happened also in 2023. This was what is the bomb blast case that happened in the Lajpat Nagar market in South Delhi in 1996, where 13 people were killed and 38 were injured. The court held that in this particular case, which was tried under TADA, that the 6 people who were involved who were accused should be convicted. Now, 3 were sentenced to death, that is Mohammad Naushad, Mirza Nizar Hussain and Javed Ahmed Khan. On appeal, the High Court acquitted two of them and commuted only one, and commuted the third person's death sentence to life imprisonment. Now, what I feel that one should keep in mind is that while death sentence may not be the rule, it is an exception, one must understand that yes, heinous crimes can be punished with life imprisonment, which is also a very difficult sentence that a person has to go through.
Ma'am, is there death penalty in other countries as well?
Yes, certain countries have abolished death sentence. This can be seen on the screen below, where we have mentioned 8 countries, some of whom have retained the death sentence and some of whom have abolished it.
Ma'am, lastly, how would you conclude the whole matter?
Well, I would say that though death penalty in India remains a contentious issue, balancing the state's duty to protect society with the rights of individual is imperative. The legal framework has evolved in such a manner that there are safeguards to ensure fairness in awarding the death penalty. The judiciary, however, has to be very careful when it is upholding human rights, but at the same time, it must also ensure that death penalties are given in the rarest of rare cases. Thank you, dear viewers, for watching us.
Ma'am, it was an absolute delight to hear from you today. We'll soon be back with another video. Till then, stay tuned to our channel and kindly like, share, subscribe to watch other amazing, insightful videos pertaining to various legal issues. Thank you all.
Thank you.